nationality, no nationality lecture. And the Law Society is hosting this particular talk, and it has to do with a number of issues. We have very knowledgeable people who are willing to talk to you today, have taken up their time. We thank you for taking up your time to come here today. And before we do anything, are we going to have the anthem or something? All right, fine. So my name is Shledon A Mitchell. I'm a year 3 law student here. And it's my pleasure to be the moderator today. And we do have Miss Arlene Elias-Roberts, Alicia Elias-Roberts, to my furthest left, your furthest right, Mr. Timothy Affonso in the middle, and Arlene Chochan, year 2, also a law student. So I'm going to invite Ms. Arlene Chochan to give the opening remarks. And to give her round of applause.
Good morning, everyone. Presenters, Law Society executives, students, especially invited guests. As Mr. Mitchell said, my name is Arlene Chochan, and I am the Education and Moot Committee Chairperson for the Law Society. Part of my primary responsibility in promoting education is to promote the intellectual development of law students. With this in mind, this seminar was one of the initiatives which is aimed at promoting intellectual development by educating law students and, by extension, students from other faculties on human rights issues. We recognize that education and legal issues such as human rights should not only be segregated to law students, but should also encompass other students in the wider student body on campus. Human rights is something that we all share. They are recognized values and dignity of all persons. Understanding human rights helps to shape our thinking and our action. Human rights are about real issues which range from the right to food, clean drinking water, the right to an education, and fair treatment regardless of gender, sexual orientation, and religion. So this seminar, one of the reasons for this seminar is in light of global human rights violations in different subject areas such as crimes against sexual minorities, child abuse, which is rampant in Trinidad and Tobago in the news these days, as well as the massacre in Syria. The Law Society felt obligated as future lawyers to promote awareness among our colleagues and other students on campus on a number of these issues. But when you hear human rights, how many of you actually know what human rights is? Okay. Well, according to the United Nations Declaration on Human Rights is the inalienable rights enjoyed by all persons by reason of being human beings. Inalienable means that these rights cannot be taken away from you. But it's not absolute, but that would be a discussion for another discourse. So some examples of human rights are the right to life, liberty, equality of treatment, etc. In closing, I just want to say that I hope this seminar empowers you to break the silence on human rights violation as a result of being educated on these issues, because education is the main vehicle to promote social change, and it should empower you to be the change that you want to be. I will now pass you over to the moderator.
Beautiful. I'm glad I didn't have to tell you to do anything at that point. You all did what came naturally. Well done, Ms. Arlene Chochan. Now, our first speaker is Mr. Timothy Affonso, so I have to give you a little bit of this man's history, a little bit. I know that you all are familiar with him, but Timothy Affonso is an attorney at law. Don't do it. They know you? Do you all know this man? No. Alright. The audience beckons, I must comply. So he is admitted to practice law right here in Trinidad and Tobago, holds a Bachelor of Law degree from the University of the West Indies, legal education certificate from the Hewarding Law School, a Master's of Law from the University College Law in Public Law and Human Rights. He is a National Scholarship winner. He has worked as a state prosecutor in the Office of the Director of Public Prosecution. his professional interest has focused on international law, and he has worked with the Ministry of Foreign Affairs and the Ministry of the Attorney General, where he focused on extraditions and human rights. He currently is a lecturer at the Faculty of Law, that we know, at the University of the West Indies, St. Augustine, in contract law and human rights. He has published in the area of child rights with a specific focus on child abuse and the rights of parents. And now, without further ado, I give you Mr. Timothy.
Thank you, Shledon. Just some points of clarification. I do not teach human rights. I teach legal methods and contract law, contract 2, and property 1. And it's called the University College of London. That would have been my mistake if it's not on the paper.
Very.
Okay, now we're talking about the rights of the child. Now this is an area that I feel very passionate about. But many people, when we start talking about the rights of the child, it comes back to this basic concept of what are we talking about when we refer to a child. Now, a child, according to Article 1 of the United Nations Convention on the Rights of the Child, says it's every human being who's below the age of 18. Now, whenever we begin a discussion or discourse on child rights, this is the effect in the audience. This is what happens. Controversy is created, defensive attitudes are created, and they are usually cultural, relativist arguments. Now, let me explain these things to you. If I say that I disagree with parents' rights to beat their children, that's my view. If I say that children have the right to speak their mind, they have the right to voice their own concerns, they have the right to articulate their points of view. If I say that if you have been hit by a parent, you have been abused by your parent, the side effect of that is people begin to attack, or I'm questioning your traditional practices. I'm asking you to question the activities of the persons who brought you up, your parents. And many people get very defensive when they say beating is bad, because the automatic response is, I was beaten and look at me. I turned out fine, I'm in law. And I think that actually goes against your argument that you turned out fine. Now, this point of cultural relativity, that is a jurisprudential theory that says any barbaric practice can be justified on the basis of cultural relativity. That means you can't comment about my cultural practices because this is unique to my culture. That argument, that particular jurisprudential theory has been allowed to justify things like FGM, female genital mutilation of children, forced virginity testing on young girls. That argument allows people to circumvent an argument of human rights violations against children, arguing that what we are doing is not a human rights violation, but a traditional cultural practice. That is why I totally disregard anyone who seeks to argue against any human rights violation, particularly child rights violations, on the basis of cultural relativity. My question is why? Why are we so opposed to standing up for the rights of children or articulating our views on children in a modern concept? It stems from the fact that people do not understand the construct of a child. Now, I have had issues with certain definitions of childhood. So Article 1 of the Convention on the Rights of the Child labels a child anyone below the age of 18. Yet they say in Article 38 you need to be 15 to go to war. So the Convention on the Rights of the Child says that you can go to war before you can become an adult. You can go to war at 15, but you don't become an adult until 18. Our Sexual Offences Act says that anyone below the age of 12 cannot be charged under the sexual offences legislation. So I can think the rationale may have been that maybe persons who are alleged to have committed offences under the Sexual Offences Act must be adults biologically. But there are offences under our Sexual Offences Act, such as the sexual indecency offences, which do not require sexual maturation. The effect of that therefore means that having an age limit which exculpates children from liability, in my view, is wrong. So yes, I am arguing that if children should be treated in a particular way, they should also be given the responsibility of their actions. Now we have the Children's Act, and let's not even get to that Children's Act. And they pick up numbers, I don't know where they get the ages from. So you are a young person if you are between the ages of 14 and 16. You are a child if you are below the age, I think it's below the age of 14. Some places give you age of 8, some tell you 7 depending on the amendments. Other places tell you that depending on your age and the type of offense you're charged with, you will actually go to an industrial school versus jail or an orphanage depending on the magistrate. Everything is discretionary and I don't know the basis of these ages. What is the rationale? What is our construct of childhood? What are we thinking of when we think about a child? Now let's deal with these 2 points, and it comes focused mainly on the purpose of this presentation. The first point is that a child must never be beaten. That's my first assertion. And the second assertion is parents have no inherent right to smack their children. I am saying parents do not have a right to hit their children. Anyone agrees with that? I expected to know. Now let me give you some examples, and you tell me what you think about it. A man is walking down the road with his wife, and she wants to go shopping. He gives her a hard slap in her face. Anything wrong with that?
Yeah.
Why?
Because really man, it was back when you were.
Brilliant argument. But let's stick with that one. Church goers, Bible thumpers, pass a place in Europe and see individuals dressed in a unique way. So what they do is they pull out a gun and shoot them. So they shoot persons who have a different sexual orientation because of their beliefs. Anything is wrong with that?
It's contradictory to the whole Bible toting thing. Killing.
I'm stamping out God and Solomon Gomorrah. That's what I'm doing. Yeah. I'm stamping it out.
But God did that at the time. No?
Okay, good. Now, in each of these situations, we have legislation. We have the DV Act, allowing women to bring an action against their husbands or their cohabitant spouses, if in fact the cohabitant spouse is engaging in any form of violence. They can articulate the abuse being meted out against them. The same thing, any minority group, and I'm using this term minority not in relation to numerical figures, but in relation to persons who are not mainstream. Any minority has the ability to speak on behalf of themselves when they are being abused. Children do not have that right. Children need to ask the abusers to articulate the abuse for them. That's not happening. So there is a disconnect in this one category of minority where the abuser or the abused cannot articulate his abuse. He is voiceless in the abuse. It's further exacerbated that we have laws in every single area of our society that tells us when a child can do what. Now, you tell me, if our age of majority says, even the United Nations Convention 18, what happens on the night of our 18th birthday? What happens on the last night of we're 17? What happens that suddenly makes us 18 and now we're an adult? What happens that ushering into our 18th year of life makes us no longer a child? That is the arbitrariness of the figures. And the same way that we must protect the vulnerable in society, I dare say that children reflect the most vulnerable group in society. Because for every minority and for every issue that an adult minority would face, children face that and more. So when men say we are not being treated equally, fine, I agree. A young girl will not be treated equally because she's a girl, and on top of that she's a child. Now we have recent cases where girls have complained to their parents, their mothers, that they're being sexually abused by male relatives and sometimes spouses of the mother. And the mother beat the child. So this is the path that a child who's being abused faces when he or she voices the abuse. Now, let's take this one. Everyone likes this one because we can identify with it. Article 91 of the United Nations Convention on the Rights of the Child says that states must take all appropriate measures to protect the child from all forms of physical, mental violence, injury, or abuse. Now, the concluding observations from the Committee on the Rights of the Child specifically says that corporal punishment is a form of abuse. Now, 28.2 speaks that discipline at schools should be administered in a manner consistent with the child's human dignity. That therefore means they're not telling you you can't beat in school. They're just saying that whatever form of discipline you decide to use, you must keep the child's dignity as the main objective. But then this is what our law says. Section 22 reserves this concept of reasonable punishment. That means you can beat as long as it's reasonable. Now this concept of reasonable punishment went up to Canada, it went up to the Privy Council. You know what the decision was on what constitutes reasonable punishment? As long as it doesn't leave a mark. That's a ridiculous argument of the judges on what constitutes reasonable punishment, but it's statute. So we have to find a scope for the legislative framework. You all know how you get around beating children so they don't leave scars? You beat them on the soles of their feet. You know it hurts more than your hand, and you don't see marks. Now, put that in some shoes and socks. We're good to go. The last administration, and this is not a political discussion, we're talking about laws which transcend political parties, and we're speaking about governments. So the last government proposed this legislation, or the package of children's legislation was considered to be a big a forward step in protecting children's rights. However, we only got one piece of the five pieces of legislation passed. Nothing shall be construed. Nothing, regardless of what they say in that piece of legislation, nothing shall be construed as taking away or affecting the right of any parent to administer reasonable punishment. And reasonable punishment in relation to any person other than a parent does not include corporal punishment. So what they're saying is, if you're looking after a child, but you're not the parent, you can't beat. But once you give birth, you can beat that child. It's not men alone, because 30% of our population are single mothers. And there is a correlation between frustration in single-parent homes and the beating that a child will get. I'm not upset with you. Now, these are some scientifically proven effects of beating children. Stealing, truancy, temper, hostility, disobedience, developing an authoritarian personality, lying, wife beating, depression. I would put spouse beating there because sometimes wives beat husbands. Depression, alcohol and solvent abuse, and racism. Now, when does corporal punishment occur? Now, people have argued, and this is legal theory, that corporal punishment usually occurs out of frustration. Now, there are religious arguments. People want to say that the Bible says spare the rod, spoil the child. Does not exist in the Bible. Any of you think that you can find it in the Bible, go and search for it and find it. It is in a poem written by Samuel Butler. There are other phrases that can be found in the Bible which seek to have the same effect. But if you look where they can be found, it actually is in Proverbs. And it was speaking about a father who had a disobedient son, and this is what he did. The end result was that his son, Rehoboam, that's how you pronounce it, became the most violent ruler ever, which his father says could have been linked to the abuse of the child, the beating that he got when he was a child. Hinduism, Islam, no religion justifies beating children. Yet we seem to have this skewed view that we can use our personal beliefs and our religious beliefs to justify these barbaric acts. Now, corporal punishment is just, to me, one of the most visible signs of abuse that we can see in society. Have you ever seen children behave badly in the mall, the supermarket, and what is your response? If that child is mine, I get a slap a long time. Or you would think that your children will not behave like that because you give them a sound beating at home. They'll be afraid to go outside. And that's the effect of corporal punishment. Corporal punishment creates fear in children. And most times, children are unaware of what they're being beaten for. So there is a disconnect between the forbidden behavior and the punishment that is being meted out to a child. Also, the younger the child is in respect of being beaten, children have a difficulty engaging time. So they may actually think that 4 strokes or 4 slaps could feel like lengthen the period of abuse. Also, when pain does not end after they've been given a slap, so they feel it after the lash has stopped. They question the length and they don't know how long it actually is. It seems exaggerated to the child. So you may think I slapped the child and now he's sitting down quietly. But the fact is you've caused psychological trauma to the child. And if you continuously treat forbidden behavior or unwanted behavior with violence, you have trained the child by using yourself as a model of inconvenient or inappropriate behavior is okay to react. You can react to that with violence. So anyone who says that there is no correlation between a child that has been abused and an adult that is abusive, in my view, is ignoring basic facts. You cannot experience abuse and not in some way have that abuse affect your life as an adult. Now, this is a serious issue for me. And I'm saying your discretion is advised. It's very difficult to talk about child abuse and not get a little bit sensitive or emotional. But my issue with this is that parents always say when I talk to them, I don't abuse my child, I give them a little slap. That's one parent's view. And I am not saying that I am saying that every slap is abuse. So I remember I had to speak to my parents and said, I'm going to let people know that you'll abuse me. You'll abuse me for years. The reaction on the part of my mother was she cried. She said she'd never do it again. If she knew then what she knows now, she would not do it. My father said, if you're rude again, I'll slap you again. The problem is that because corporal punishment is linked to frustration in parenthood, in parenting, there is the ability to escalate. So if you use a slap or a smack as your currency of discipline for coming home late or for being rude, as the behavior becomes, Arlene, go back. Arlene, back. Back space. So much for the effect. Yes, as you use your currency for small events, as the event becomes worse, you have to increase your currency. So a slap is not sufficient anymore. You have to do two. You can't use your hand. You use an object, and then it becomes escalated. Let me give you all some examples. Now, James Bulger. This is the age, this is how he looked when he died. Now, James Bulger is the victim of a murder that took place in Liverpool by Venables and Thompson, two young children. They dragged him through the central streets of Liverpool midday, and they kicked him, cuffed him, beat him. No one in Liverpool stopped them except to ask, why are you doing this? And they said, well, this is my younger brother, and everyone said, okay, great. They then shoved the batteries up his rectum and rested him on a train track, and the train dismembered him, split him in half. So the next example. Akil Chambers, everyone knows Akil Chambers. He had gone to a children's party. He was found in a pool, drowned, and when they did the autopsy, they found that he had actually been buggered. Up to now, they still don't know who did it. Evidence in relation to the DNA was missing. Amy Emily Anamantulo. Amy had been beaten since she was born by her mother's boyfriend. They out cigarettes on her skin. When she was carried to the hospital, she had broken ribs and limbs, and she had been sexually abused. I think she died at the age of 4. Next. Sean Luke. Sean Luke is our local James Bulger. He had been beaten by 2 boys, sugarcane was shoved up his rectum, and he was killed. The person still have not been prosecuted. I mean, the trial was, the matter is going on. Daniel Guerra, he left home to go to a shop to buy soft drink, and he never came home. They eventually found his body in a river. They believe that the person who killed him was a relative of the family and a police officer. Now, there are other forms of child rights violations. So that's just the extreme ones, and most of them, those examples took place in Trinidad. Now let's look at some of the other examples, and these are global examples of child rights violations. Child camel riders in Qatar. Now these are young children who are kidnapped from Pakistan and India, and they are forced, they can't see it here, but they're strapped into the camel, So they can't come up. Their legs are tied down, which usually causes dislocation of limbs and broken legs. And they are light, so they can ride for the sheep. So the wealthy people keep them. This is a form of child slavery, and this is what they are made to do. Okay. And it still goes on. It is entertainment. It's like horseback riding. Like, they bet the sheiks and the wealthy persons in the Middle East bet on which camel will win. Yeah. Force feeding girls in Mauritania now. In Mauritania, they actually believe that the heavier the woman, the more attractive she is. So therefore, they force feed the girls. So you'll only, if you see the video clip, she's actually slapped and beaten to drink the milk. And it is a very fatty milk. I can't remember the animal that they got it from. It's not a cow. And she's slapped so hard sometimes that she vomits all the milk that she took down. And this is done, she sits down here, drinks, eats for like hours at an end. Now this is activist stance virginity testing for focusing on girls. Now this is in an African state, but there was actually a proposal in Jamaica about 7 years ago to forcibly test primary school girls to see whether they are virgins. This was a proposal made by Parliament in Jamaica 7 years ago to forcibly test whether girls are virgins or not. I still don't understand the point of it. We've all seen FGM. I thought any picture on FGM would have been a little bit too obscene. But these are the tools used for FGM. One is a dull knife and a razor blade. And this is what children are, young girls, sometimes 2, 3, are held down by family members while they cut them up. And they argue this based on traditional values, cultural relativity. 600,000 children a year forced into slavery today. Today. Now let's look at some examples in Trinidad. Now, I have some examples here, and the examples are recent examples that took place in June or July of this year in relation to some child abuse cases. So there was the Kamla Ramcharan, and she was a single mother of 4. And in response to an allegation that her daughter had actually stolen in school, she took the child's hand and placed it on a tower. Now this is the conviction. She was convicted and sentenced to 3 years. Now the district magistrate, Gillian Scotland, said that this is a heinous way to punish a child. The child who gave birth to this child is innocent. She did not ask to come here. What interactions you have with her father have nothing to do with food. There's another example where the child, she was actually being sexually abused by a friend of the mother, and when she went to complain, the mother beat her. Now the woman was only convicted in 2012 for an offense that took place in 2003. 2012 she was convicted. And she was given 9 months jail and was ordered to pay a fine of $5,000. So the man in fact was having a relationship with the mother. The court said that we need to have an advocate to the child in the USA to step into matters that come before the court, because they are saying that we need advocates for children. So they recognize that there is a problem in respect of children's ability to articulate their abuse, particularly when the first contact point of the complaint is the parent who is not going to further the abuse claim. Now there's an example, and I don't know if you all noticed, Wednesday the 19th of July, a young boy was locked in the kennel overnight because the father's words were he was not listening and he was being stubborn. So the father and the brother of the father, which would be the child's uncle, held him down, took off all his clothes, locked him in the kennel. Now the child screamed for the entire night and the neighbors heard. The neighbors actually didn't come until the following morning, and it was at that point that they realized that the child had actually, he was undernourished, he was traumatized, and they took him away from the parents. Up until the point that this particular thing had been done, the person had not been convicted yet, although they had been charged. Now, it is our belief that we have to do something to protect children. And the question is, what can we do? Now, there are arguments that maybe we need to set up non-profit organizations that argue on behalf of the rights of children, so that they actually bring claims on behalf of abused children against the persons who are supposed to be responsible for their care. Now, the US has a very detailed system, as does Canada, as does the UK, and many European countries, Australia as well. We have no such infrastructure that works in Trinidad. Now let's look at resource allocation, which is a serious issue, and I'm not spending much longer on this. Now, in order for us to set up any welfare system, we need to have government financing. We need to have the government use children's rights as an issue, a real issue, and not a political debate. We cannot have governments, and I'm not talking political parties, governments use the child or the children's protection issue to gain political points. At some point in time, we need to elevate our discussions beyond political mileage into the realm of what is best for society. And if we do not arrest the issue of child abuse now, it will lead to greater social consequences later on. Now let's look at this graph. Now these are just a couple examples of expenditure that took place since our last government has assumed office. Now, government expenditure had increased in the last budget, not this most recent, the last one, from $50 million, about $46 million, to $100 million because we need to have more fun on the streets for Carnival. And most of that was actually spent on prize money. NIPDEC, which is our housing corporation, was given $1.5 billion to build more houses 2.5 years ago. The houses are still not complete. CLICO, $1.5 billion was the first payment, with another 1.5 coming out, so this is actually less than the 1.5 of the first payment. And this was to give investors in a failed financial institution. Now in India, everyone knows about the India trip. That was $4.6 million. The point that I left out was the $40,000 paid by the Ministry of Social Development for a wedding. A wedding. Now let me give you the details. Let me tell you. The Minister of Social Development paid out $40,000, which is $6,100 to fund a wedding to a poverty-stricken couple, as he described them. The ministry organized the cake, decorations, flowers, DJ, drinks, tables, chairs, food for 50 guests, wedding rings valued at $2,000. They couldn't go to the Red House. At what point in time do we have to fund? I'm saying we because we are the ones who give them the money to spend. What point in time do we have to give $40,000 for someone to have a wedding, but we can't give children proper protection? Now, we do have the Children's Life Fund, and I heard up to yesterday the Prime Minister made a statement that 40 children have benefited in the last year, 2.5 years. And I'm saying anything we do to protect children is fine. But I'm also saying that we need to have systems in place to deal with children who are not dying from illness. What happens to the child who unfortunately is well, but getting beaten every night they go home, or not given food when they go home, or being sexually abused as Amy, and we saw what happened then. We only find out what happens to children after they die. And then there's a common uproar, how dare this happen? But we turn a blind eye every time we see it, and the small things arise when we see someone hitting their child in the supermarket. Now in the past I've told people, stop hitting the child. And you know what response you get? I can't use those words here. And the fact that you feel comfortable cursing in front of your children, you should be locked up. You should be locked up as a parent, and bear in mind, I'm arguing against cultural relativity, but I have been told some things by my parents. So I'm owning the abuse. I have been abused, and I don't say, and look at me. I say, despite the abuse, I have been able to overcome it. But not everyone can automatically say that they were abused, but they are fine now. The unfortunate part is the place and the time when we adults, because you're now adults, so you're law students, that's nonsense. You have the ability to arrest and to cause change. And every time you stay quiet, when you see abuse happening, regardless of how small, you are encouraging the end result of Amy, of Sean, of Daniel, of Akil. Now, this ties back into the point we're making of what we need to do. And we need to align our domestic laws with our international obligations. We can't have international obligations saying one thing. We've signed and ratified them, yet we are doing absolutely nothing to incorporate that legislation meaningfully into our domestic legislation. It is, in my point of view, diplomatic lip service, where we are simply doing what we need to do to have an impression at the international level, but we do nothing to meaningfully entrench those rights in our domestic laws. And this speaks back to the point of allocation of resources. So, yes. So my advice to you is to please protect the children in your lives, younger siblings, neighbors, friends. You need to be their voice because they have no voice. Okay, and thank you. That's the extent of my response.
That was a very passionate presentation of some very heavy ideas that we don't take enough time to think about. So thank you again, Mr. Affonso. Now, hopefully that was stimulating, and hopefully you have room for a little more stimulation. And for that, we'll ask Ms. Elias-Roberts. Oh, wait, hold on a second. We're supposed to be doing something. Does anybody have any questions? Yes, concerning that last presentation. Yes?
I wanted to ask, what are social workers doing to remedy the situation that we have with students? You know, you look at American television, you see social workers going to the home, investigating, keeping record of what is going on with the child.
Could you say your name though? Could you say your name?
Cassie Bisram.
Cassie Bisram wants to know what are our social workers doing here in Trinidad and Tobago to arrest some of these situations.
Well, you have to remember that social workers are only involved in the process after the court has involved with them. So that's the problem. The problem is we have an end involvement, whereas I think we need to have a beginning involvement. We need to have something which allows children to be constantly monitored as they are being progressed. And it's simple. You can have it in primary schools, secondary schools, meaningful welfare officers that exist within the school to enable children to have an outlet to voice concerns, rather than having it after a child has been abused for years, go to court, and now the court is saying, okay, we'll send your welfare officer. We don't need that officer then. We needed it before. What are we going to do now? Simply document how the child is reacting? So yes, we have a system. I just don't think the system is the most effective system.
Thank you.
I can let some on.
Oh, hold on. Before you do, there's another. So you'll put up your hand next, and we will take you next. There's a lady in the
I was going to provide some information in the last question.
Okay. Well, hold on 1 second. Could you allow this? But definitely come, Jimmy.
No, I worked for 3 months in the social welfare division a few years ago, and it was quite elucidated to see what is happening in that division. Historically, a lot of the jobs in these government offices, particularly welfare and labor, have been areas of political patronage. So it's staffed by a whole cadre of people who are there because of their political affiliation and not properly qualified. So the work attitude towards this is like another job. And I believe for that kind of job, it requires a level of passion and a level of dedication to do it right. So you have a whole set of people, and I'll give an example. So being a student inside of there, they gave me a whole file of people who were waiting for public assistance claims and pension approvals. And you have to go to the upland areas to verify people's income and their living conditions and so on to approve it. And they had these files in the office stacked up to the huge stacks of files. And these ladies come in every day, do probably 1 case, 2 cases. And I sat down in the office, and after going out in the field for a few days, I realized how dire the situation was, because people wait like 3-4 months for public assistance, sometimes 6 months, 8 months. So I used to take by geographical areas, take all the files, and ran through like 15, 20 a day. And I was wondering why these people taking so long and they're such a big staff. But it's the attitude of the workers inside of the public service. And none of the supervisor wants to deal with these people, because he's also a political appointment. And invariably, depending on which regime it is, he might be the wrong person to deal with a different crowd at the bottom. He might be an Indian supervisor and he wants to mess with them Africans at the bottom. Or he might be vice versa. So it's a stalemate. So everybody sits back and watch the show go on.
Thank you very much.
People suffers.
Thank you very much. Thank you very much. Your question?
Hi. Not so much a question as a couple of comments. My name is Anusha, and I'm here from the Institute for Gender and Development Studies. I just wanted to also kind of give support to your cultural relativity argument, and I think that is relevant, and that the UN doesn't really have the authority to go into different places and tell people how to run their countries unless they're reported and so on, so I think that's really important. You also mentioned that we have to be responsible for our international obligations. And I think, like, when you're dealing with the rights of children, one of the really important aspects that, well, you didn't really touch on, but I think I could point out, is the Marriage Act of Trinidad and Tobago, which basically make it okay in terms of culture for different religions for children to be married to children, or children to be married to adults. And as statistics show, there are cases of even 12-year-old girls being married to 65-year-old men, and so on. And we have done a lot of public consultations on that. The government has even done a public consultation on that. And of course, the marriage acts are in direct contravention with our statutory rape laws and the Convention on the Rights of Children and the Convention Against the Domestic Violence Against Women UN laws. Also, the Children's Rights Bill that was just passed in Parliament sort of criminalized same-sex children relations, and did criminalize it, and did not criminalize the relations between minors that are of different sexes. So that's sort of leading back to when you do the human rights and sexual minorities part. And also at the Institute, we have this nationwide campaign, and I'm sure people have heard of it, called Break the Silence Against Child Sexual Abuse, with the Blue Teddy campaign. So that's really taken off for us, and we have we sell the pins, and we raise a lot of money, and we do these walks, because we really feel that the rights of children and the rights of women and children are the most vulnerable in society.
Thank you. We will take 2 more questions.
Good morning, David Edmond is the name. Mr. Affonso, you spoke about, I think it's Article 19 and 28 of the UN CRC, which speaks of not disciplining a child in such a manner that degrades their dignity. Just wondering, how is that possible?
I agree with you, and you have to remember that the American Pediatric Association, they actually gave you, they set out a list of things, alternatives to teaching children, and many of the things actually speak to coming down to the child's level, taking eye contact, letting them know the problem of their behavior. If you look at Super Nanny, she actually implements all the steps required or set out by the American Pediatric Association. But you also have to remember the point made by the lady from Gender. Because the UN Convention on the Rights of the Child is an international treaty, they had to word the document in such a way that they do not bind any state, because they can't tell a state that they have to do something. So it's worded in this very general way, where if a state were minded to abolish corporal punishment, and it's only been abolished, I think, in 27 states worldwide, they can. But for a state that does not want to do it, they can still enforce the legislation. So I agree with you that that concept of disciplining a child without affecting the child's dignity, it's not impossible. The unfortunate part is that most people tend to use corporal punishment as the only mechanism of discipline, and I feel that is contrary to any concept of a dignity of a child.
Very good.
And when we've been talking about the physical aspects, what about the mental degradation of a child? Like, that could affect his or her dignity as well. The mental aspect has a lot more, I think, to do than, well, physical is justified and everything, but the mental aspect of it is very frightening as well.
You mean mental, psychological effect?
Yeah, the psychological effect of abuse.
Exactly. I mean, when I was speaking about,
they can't, if they beat them, that will affect them in a great deal, but what if they're like constantly condemning and all those things?
Verbal abuse.
Yeah, well, psychological abuse, I mean, I think is definitely important. I was just focusing on some of the more
Visible.
yes, outwardly visible things that you can
But do they do it like separately in the UN? Do they have separate
There's a
rules
generic
for
way of expressing it. So children have the right to be free from, I forget the actual wording of it, but it speaks about children having the right to an environment that enables the best interest of the children. That's Article 3, which actually is supposed to guide the entire treaty. So anytime you're confused as to what the child should or should not get, is this in the best interest of the child? And no one can ever argue.
Clear separation of it, or
No, there is a clear separation between sexual abuse, psychological abuse, and physical abuse. Yeah.
Well, thank you very much for, begging some questions I would also like to add this, however, that what Mr. Affonso was talking about was the fact that we have a very reactive system and not a proactive one. So when Jimmy was talking about stacks of files, however high, that's still after significant abuse has been meted out to children already. So we need to have a more proactive form of monitoring and evaluating whether abuse is happening. It could be from the education system to how policemen are trained to how our society just needs to be mindful of these things, and that's why these kinds of conversations are extremely important. So thank you very much again, Mr. Affonso and the audience. Do give yourselves a round of applause. Now we're on to the next speaker, and it's Miss Elias-Roberts, and I have a brief bio on her as well. Miss Alicia Elias-Roberts is a lecturer at the University of the West Indies, Faculty of Law, right here at St. Augustine. She's responsible for lecturing in public international law, and she's previously lectured in public international law at the University of Guyana as well. Additionally, in the past, she has been a legal treaty consultant with CARICOM, and she is an attorney at law admitted to practice in New York, and she possesses a legal education certificate to be admitted to practice in the Caribbean as well. Ms. Roberts obtained her legal education from the University of Guyana with her LLB, University of Oxford with a Bachelor of Civil Law, and University of Houston, where she obtained a master's degree in law in energy, environment, and natural resource law. So without further ado, I give you Ms. Alicia Elias-Roberts.
Thank you, Shledon, and good morning, everyone. I'm going to begin to this first human rights seminar organized by the Law Student Society. My participation here has given me the opportunity to actually work on a paper which I've started to research during the summer. And I've got some cobweb and some dust. And after Arlene asked me to do this presentation on human rights in the environment, I decided to tailor my paper to suit human rights in the environment, because what I was actually researching was public interest litigation and standing in environmental litigation, public review, and the presentation would entail, because I don't have a PowerPoint presentation. What I'll do is that I'm going to look at the evolution of human rights in the environment first, and then I will do a comparative analysis of the doctrine of standing, look at standard. What you realize is that the argument surrounding environmental rights usually focuses not on environmental quality, but sometimes procedural rights. And that is access to environmental information, access to justice, and participation in environmental decision making. So actually my research on public interest litigation and standing is directly linked to human rights in the environment, because it entails a failure by the state to regulate or control environmental nuisances or to protect the environment, and to show how this may interfere with individual rights. And what I'll do is that I'll go through a couple of case studies to highlight the evolving jurisprudence in this area. So briefly, environmental law might be new to you, and there are many unique features of environmental law that you should note. One is that environmental litigation usually has barriers for those who seek to protect the environment through litigation. And that is why standing is an important issue, because if you have NGOs and parties who are not directly injured by an environmental disaster, for instance, to go to the court and to have standing is usually a barrier because of the feature and the nature of environmental harm. And another general feature of environmental law is the way in which it has developed and evolved, which is relatively recent when contrasted with other areas of law. Environmental law could be pinned back to, the development could be pinned around 1970, in contrast to other areas of law, if you're studying criminal law, tort, contracting, you can go back to cases hundreds of years old and you have precedent that you can lean on for the development and evolution of the principles in those various areas of the law. But the awareness and the development of environmental law is relatively new because of the general awareness that human activities could affect the environment and the need to regulate it in a legal way. So if you look back at the first set of treaties that dealt with protection and conservation of wildlife, coming from the 19th century through to the 1972 Stockholm Conference and human rights on the human environment, then from that international conference that galvanized a lot of national, regional, international regulatory agencies that were developed in municipal jurisdictions to deal with the regulation of the environment. So just give you that broad overview. And when you look at municipal law, you see that legal systems protect the environment historically, incidentally, through the protection of rights, private individual property rights, and private interests. So certain tortious actions, nuisance, actions which interfere with a person's right to their use and enjoyment of their land, noise pollution, and so on. Those acts were brought, but they were not brought to protect the environment solely, but they were really tangentially protecting the environment, but were more concerned with human enjoyment and the infringement of a person's right. So when we look at environmental rights, because we have human rights, but if we look at contemporary society and the argument for environmental rights, you realize that it doesn't fit neatly into any of the current generational human rights. I'm going to look at two perspectives initially, the anthropocentric approach and the ecocentric approach, and then after analyzing the public interest litigation cases, I'll look at that approach, a public interest approach, or a community kind of solidarity approach to environmental rights. So the first is the anthropocentric approach. And what this holds is that existing civil and political rights could be used to give individual groups and NGOs access to environmental information, judicial remedies, and political processes. On this view, the role is one of empowerment, facilitating participation in environmental decision-making, and compelling governments to meet minimum standards of protection for life, private property, and property from environmental harm. So insofar as the anthropocentric approach is concerned, it focuses on the harmful impact on individual humans rather than on the environment itself. It amounts to greening of human rights law rather than the law of environmental rights. The second approach, the ecocentric approach, is treat the decent, healthy, or sound environment as an economic or social right, comparable to those whose progressive attainment is promoted by the 1966 UN Covenant on Economic, Social, and Cultural Rights. The main argument for this approach is that it would privilege environmental quality as a value, giving it comparable status to other economic and social rights, such as development and priority over non-rights-based objectives. Like other economic and social rights, it would be programmatic and in most cases enforceable only through relatively weak international supervisory mechanisms. This second approach, nevertheless, is one that will always be vulnerable to trade-offs against other similarly privileged but compelling or competing objectives, including the right to economic development. So one of the main questions that I'll ask in this presentation is, should we continue to think about human rights and the environment within the existing framework of human rights law, in which the protection of humans is the central focus, essentially agreeing of the rights to life, private life, and property, or has the time come to talk directly about environmental rights? In other words, a right to have the environment itself protected. Should we transcend the anthropocentric approach in favor of the ecocentric approach? Or is there an alternative that would be better suited, especially here in the Commonwealth period? What you'll notice is that this is not a new question. There are several academics that have written on this area. And interestingly, in 1972 at the Stockholm Conference, the United Nations Conference on Human on the human environment, the international community had declared in that declaration that man has the fundamental right to freedom, equality, and adequate conditions of life in an environment of quality that permits a life of dignity and well-being. And he bears a solemn responsibility to protect and improve the environment for present and future generations. And this grand statement might have provided the basis for subsequent elaboration of the human rights and environmental quality, but its real-world impact has been noticeably modest. If you look at the 1992 Real Declaration, which is 20 years after the Stockholm Declaration, it makes human beings a central concern of sustainable development, but it omitted to frame the kind of fundamental right argument to the environment as did the Stockholm Conference. So there was a change from 72 to 92. And that is possibly because of the uncertainty and indicative of the debate surrounding this argument that there is human rights in development of environmental law. And several academics, including Bernie Boyle and Bredgerell and Professor Shelton, has written and commented on this issue. So there's still uncertainty and room for debate. I'm going to look at a couple of cases that dealt with this issue of human rights in the environment. One is the Ogoniland case. You know, from the 1981 African Charter on Human Rights, they have a proclamation that stipulates that there is a right to general satisfactory environment favorable to their development. And people have a right to the best attainable standard of health. In the Ogoniland case, the African Commission on Human and People's Rights concluded that the environment degraded by pollution and defaced by the destruction of all beauty and variety is as contemporary to satisfactory living conditions and development as the breakdown of the fundamental ecological equilibrium. It's harmful to physical and moral health. It held, and this is the African Commission, that Article 24 of the African Charter imposed an obligation to states to take reasonable measures to prevent pollution, ecological degradation, to promote conservation, and to secure ecologically sustainable development and use of natural resources. Specific actions required of states in fulfillment of some of the provisions under the African Charter include ordering, at or least permitting independent scientific monitoring of threatened environments, requiring and publicizing environmental and social impact studies prior to any major industrial development, undertaking appropriate monitoring and providing information to those communities exposed to hazardous materials and activities, and providing meaningful opportunities for individuals to be heard and to participate in development decisions affecting their communities. The Commission's final order is also the most far-reaching of any environmental rights cases. It calls for comprehensive cleanup of lands and rivers damaged by oil operations, preparation of environmental and social impact assessments, and provision of information on health and environmental risks, and meaningful access to regulatory and decision-making bodies. The Commission's orders offer a blueprint for merging environmental protection, economic development, and guarantees of human rights. The Ogoniland case is remarkable. It's a remarkable decision, and it goes further than any previous human rights case in the substantive environmental obligation It's a remarkable decision and goes further than any previous human rights case in the substantive environmental obligation it places on states. So this is a case that is unique in applying for the first time the rights of peoples to dispose freely of their own natural resources. When combined with the evidence of severe harm to the lives, health, property, and well-being of the local population, the decision can be seen as a challenge to the sustainability of oil extraction in Ogoniland. The most obvious characteristics of unsustainable development include material harm and a lack of material benefits for those most adversely affected. Apart from the African human rights case, there have been several cases before the Inter-American Commission and the Inter-American Court of Human Rights that have interpreted the rights to life, health, property, and protection from the environment. To afford, protection from environmental destruction and unsustainable development. One such case is the Maya indigenous community of Toledo case from Belize. And in that case, the Inter-American Commission accepted that logging concessions threatened long-term and irreversible damage to the natural environment on which the petitioner's system of subsistence agriculture depended. Loss of topsoil would prevent forest regeneration, damaging water supplies, and diminishing the availability of wildlife and plants. The Inter-American Court of Human Rights in the Mayan case concluded, and they cited the Oginiland case, that there had been violations of the petitioner's right to property in their ancestral land. Its final order required police to repair the environmental damage and to take measures to demarcate and protect their land in consultation with the community. The Commission's decision notes the importance of economic development, but reiterates that development activities must be accompanied by appropriate and effective measures to ensure that they do not proceed at the expense of fundamental rights of persons who may be particularly and negatively affected, including indigenous communities and the environment upon which they depend for their physical, cultural, and spiritual well-being. Unlike the Oguniland case, however, the ISCHR decisions draw heavily on the particular rights of indigenous peoples to their traditional lands, and it's unclear whether they have more general relevance outside of that context. Now, I'm going to turn to some countries in the Commonwealth Caribbean. In Trinidad and Tobago, for instance, the Constitution does not clearly provide for a right to clean and healthy environment. And in many of the constitutions in the Commonwealth Caribbean, even though there is a right to health, the environment, if you search for the word environment within this constitution, it is not there. Yes, these jurisdictions may have environmental protection legislation and agencies, but the right to a clean and healthy environment is not a right that is guaranteed in the Constitution. The Constitution of Guyana is one exception from my research, and Article 25 here, and in combination Article 36, specifically provides that in the interest of the President, the application of Jabbar and Dr. Keith Rowley, who was at the time the Minister of Agriculture, Land and Marine Resources. In that case, the Jabbars claimed the right to conduct rice farming based on the alleged verbal permission of the Minister of Agriculture. Previous government, in one of the areas, which is the most, one of the most ecologically sensitive areas in Trinidad, and that is the Nirvara Swamp area. The Nariva Swamp area. This is a large and diverse wetland renowned for its unique flora, fauna, and species of animals. It includes the manatees, birds, and a variety of fishes. This swamp is also a swamp that is listed as an area of international importance under the Ramsar Convention on Wetlands of International Importance. And notwithstanding the ecological features of this area, agricultural development and mainly rice cultivation had been going on there for over 40 years. So when an order was issued prohibiting Mr. Jabbar and others from occupying the area and cultivating there, they brought an action. The litigation was instituted by Mr. Jabbar and others to the High Court for constitutional redress in relation to the government's declaration that part of the swamp was a prohibited area for the purposes of the Forest Act. That declaration had the effect of prohibiting their continued occupation of several hundred acres in the swamp for rice cultivation. In particular, the declaration affected Mr. Jabbar's cultivation of rice in some 200 acres of swamplands in the Bush Wildlife Sanctuary. Witnesses for the government recorded particular concern in relation to cultivation in the Bush Wildlife Sanctuary, which had been declared sanctuary in 1963. It was suggested that the extent of agricultural activities in the swamp generally, and in particular, in the immediate area of the sanctuary were incompatible with maintaining the continued viability of the sanctuary. Serious irreversible damage to the characteristic iota of the swamp as a result of fertilizer and herbicides that were being used during the cultivation was contaminating the ecological balance in the area, and a lot of further contamination was predicted. So Dr. Keith Rowley, who was the minister responsible for agriculture at that time, at the time of this litigation, deposed that the government policy was governed by the findings of an early scientific study of the area that recommended preservation of the swamp in its present condition. And having notice of the rice cultivation and the operation of machinery in the sanctuary, he issued an order declaring that the area in the swamp is a prohibited area. This order apparently overlapped with the declaration of the sanctuary as prohibited area that was issued in 1989, through legal notice number 1555 of 1989. But apart from not finding any evidence of an unambiguous promise being made to the Jabbars to presiding judge in this case, Justice Lucky, rejected the argument that the government's declaration of the lands occupied by the applicants as a prohibited area, and the action by the foresters in going onto these lands and asking the applicants to move on the threat of criminal proceedings was unconstitutional and illegal. The judge quoted from a report from the Food and Agriculture Organization, which indicates a need for an overall development and management policy which should encompass environmental protection and should ensure development does not create a negative impact on the swamp's ecosystem. This case is a ringing endorsement of the relevance of the Constitution to environmental protection. In the interest of time, I'll just wrap up after this case rather than going to several other cases that I've researched in Europe and elsewhere. But the point is, the point is that even though there is the incidental protection to the environment through constitutional redress, I believe that there's a clear need for explicit protection to the environment under the Constitution. And further, when I started, I looked at two main areas for environmental protection and the human rights-based argument, being the anthropocentric approach and the ecocentric approach. But what my research has done in looking at public interest litigation, I looked at cases from India, several cases before the European community, very famous case, proposal and factorium from the Philippines. And the argument is that expanding upon the doctrine of standing, which is usually a bar to access to environmental justice, expanding upon that argument and opening the ability and access to the courts by NGOs and various bodies in which the requirement for injury is not necessary. You don't have to prove that these persons were injured before they can have standing to come before the court. But if you can prove that rather than focus on the environment and harm to the environment, then the communities and various interest persons should have standing to come and litigate in areas that concern harm to the environment, and I think that would better protect the environment. So that is the thesis so far, and still a work in progress. Thank you for your time.
Perhaps 4, maybe, in the interest of time. And is it all? Is it all? Yes. So let me, when you hear about the anthropocentric view versus the ecocentric view, the anthropocentric view has to do with human beings having, or the whole thing about the right having to be centered around human beings. Human beings have rights. But does the environment, is there a right to environment? Does that have a right by itself, or is it related to the fact that you, human, you benefit from the environment, and that's how there's a linkage between the enforcement of that right and you, the human being. So, do ask anything concerning things that are happening in Trinidad and Tobago, concerning how we manage our environment, anything at all. You all understand exactly what Ms. Elias-Roberts was saying today, yes? I feel like pointing somebody and saying, tell me what All right, very well. Thank you very much for your time and attention. And Ms. Elias-Roberts, thank you again. And I trust that that book, your research that has been dusted off, I hope it doesn't collect any more dust. I hope we just get it done. Thank you very much, and have it published. Again, a round of applause. Now, luckily for us, I left recently, just before the end of this, to find the next speaker, and he's here.
Is there any particular reason as to why you think that they implement this within their legislation?
I mean, the Constitution.
It's in their Constitution, yeah.
Right. Yes. To correct what you just said. I clearly didn't say that they're the only country with legislation, but they have as a fundamental right in the Constitution, as distinct from what my research has uncovered. With respect to other countries in the Commonwealth, it's not a fundamental right in the Constitution. the reasons, I think it's because of the constitutional revision that they had undertaken in the 80s that led to this forward-looking constitution. That at that time, it was after the Stockholm Conference in 1972. There was a lot of buzzword and work towards environmental protection. So to create a more holistic approach to environmental protection, we felt it was relevant and necessary to include that type of right as a constitutional, a fundamental right. But I can't read the mind of the other jurisdictions, so why we haven't answered yet.
Thank you very much. Additionally, when we hear a lot about constitutional reform these days, yes, you hear about it every now and again. And oftentimes, it's lost on the public because they don't even know what's in their constitution, right? To talk about constitutional reform. However, perhaps if there is going to be constitutional reform, maybe there should be something about preservation of the environment in the new constitution that we may collectively give birth to. Does anybody think that that might be a good idea?
Yeah.
All right. So, we're on to the next speaker. I had a little bit of a skipping heartbeat kind of thing happening there just now. But yes, now we have the man, Dr. Arif Bulkan, a comrade of Ms. Arlene Elias-Roberts and the other lecturers here, obviously. But he too hails from Guyana, and he lectures here in human rights law in the faculty, area of specialization, rights of indigenous people, health and human rights, and Caribbean human rights law. So without further ado, give it up for Dr. Arif.
Hello students.
Hello.
On the question of the, Alicia, permit me just to say a couple of things about the Constitution. I'm not sure, I wasn't here for the entire presentation by Ms. Roberts, but one of the things I think, this is something that we see a lot in Caribbean law, I think, generally, is that the mere, and I'm sure the point would have been how essential it is to have it in your constitution in the first place, but I think the experiences of Trinidad and Guyana are very interesting around the environment, because Trinidad doesn't have that provision, and I think a much stronger sort of judicial body, you would agree, of jurisprudence than Guyana. And there's an interesting case, even though Guyana has this right, there's an the first case to litigate the right that I'm aware of, sort of made no impact on the law. It simply repeated the right. And it was around the same case that Ms. Roberts might have mentioned about the Mayas in Belize. Same kind of case in Guyana, and the court found, even though they were carrying on with environmental degrading activities around, it didn't violate the Constitution. So I think it's an interesting commentary on just having provisions in your law, as opposed to the will to enforce them. Yeah. About sexual minorities, I wanted to talk just briefly about what the legal position here is in the Caribbean, and the implications of that position briefly, and also to look at emerging international human rights doctrines and jurisprudence around the rights of sexual minorities. Just by way of introduction, I should say that sexual minorities, I understand that might include homosexuality, transsexuality, intersex persons, and so on. So it's a wide array of people. And it's not a Western, I mean, part of the, I think the opposition to recognizing rights around this area has often been framed as it's, around terms of cultural imposition, that it's, a Western phenomenon. But actually it's not, because anthropologists and scientists and historians have documented the existence of sexual minorities, all of these kinds of things. Interestingly, not only across cultures, but also across times. So from pre-Columbian indigenous societies to modern societies, and not just Western societies, but also Asian, African, Pacific societies. And interestingly, they've also recorded it, as I said, across cultures and across times, but also across biological species. So human beings and animals, a wide array of animals, including even fruit flies. So it's not a concept, or it's not a phenomenon that is restricted to the West. The position legally in the Caribbean, with the exception of the Bahamas, is one of complete legal exclusion. So by complete, I mean both civil and criminal exclusion. So same-sex sexual activity is manifested in a couple of ways. One, same-sex sexual activity is criminalized in the Commonwealth Caribbean, except the Bahamas. And criminalization of this, so it's sexual activity that's criminalized. And the criminalization, there are certain features about this criminalization. First of all, in the majority of countries, it's between males. So not necessarily, not females, but between males. These offenses are styled a wide variety of ways. So you might have in the in Belize, it being described somewhat vaguely as against the order of nature. So that includes against the order of nature at common law, other kinds of sexual activity, including bestiality and so on. But other jurisdictions talk about a natural crime, but the more prevalent term is buggery. And again, that will apply at common law, mostly to conduct between males. These laws were inherited from Britain at the time of colonization. So when these statutes were received, those prohibitions were received along with them. The important thing to note about these prohibitions is that they apply irrespective of aggravating factors. And by aggravating factors, I mean other jurisdictions criminalize conduct, same-sex activity if it has certain aggravating factors, particularly if it's not consenting. So in the same ways that they will criminalize between opposite sex. So if it's an element of rape involved, or if it's an element of minor, if one party is a minor. But in the Caribbean, except the Bahamas, it's across the board. So that it targets whether it's consenting adults, whether it's done in private, or whether it's, all adults. And the penalties are severe. They range from 10 years perhaps in places like Antigua, 25 years in Trinidad and Tobago, life imprisonment in Guyana. They also criminalize things like serious indecency, which would mean anything short of penetration, but with a sexual element. So that's criminalization. On the other hand, there's considerable exclusion on the civil side, so that would include things like access to goods and services, housing, the other kinds of civil rights, like relating to inheritance, succession, family, property. So same-sex unions are not recognized, and spousal benefits a lot in that connection. So civil discrimination as well as criminal. The trend in the Caribbean has been, the trend around the world has been to remove these, remove this discrimination so as to equalize between same-sex and opposite sex. The Caribbean has gone the other way. So in the Caribbean, the trend has been not to decriminalize or to equalize. The trend has been actually to entrench the discrimination. So in a number of ways. First of all, in the wave of sexual reform that happened across the Caribbean in the 80s and 90s, what governments did were to increase penalties. So, and many governments did that. So these offenses, so like in Trinidad, for instance, it went from 10 years to 25 for the offense of burglary. The ambit of offense also increased or widened, so that, as I said, what the inheritance from England was a prohibition on sexual activity between males. What Trinidad did was to criminalize sexual activity between females also. So, whereas lesbians remained outside of the law everywhere else, in Trinidad, sexual activity between females was also criminalized. So, an offense of serious indecency that hitherto only applied between males was now extended to females. And one Trinidadian feminist described this as equality with a vengeance. That was followed in the way of what happens in the Caribbean. That was followed in the Bahamas, and well, Bahamas decriminalized. But what they did is when they extended some penalties for public conduct, offenses that targeted only males also targeted females. And Antigua followed the Trinidad legislation in 1995. In other places, Trinidad again. Trinidad enacted an Equal Opportunities Act. Ironically, it defined sex as not including sexual preference or sexual orientation. And that's kind of significant for legislation, because orientation is quite different from conduct. Use of the word orientation recognizes that it might be something inherent. But here was the law saying that it would discriminate, or it didn't recognize the validity of this as a ground of discrimination. The Trinidad Court of Appeal found that exclusion to be unjustified and unconstitutional. They said that the homosexual orientation was not a crime, that what the law forbade was certain types of activity, but not an orientation. So they found that legislation, Equal Opportunities Act, at that point to be unconstitutional, but they were reversed by the Privy Council. And then, in keeping with this trend to further entrench discrimination, there have been moves for constitutional reform in other places, which would include entrenching in the Constitution discrimination against sexual minorities. The process that Ms. Roberts referred to, which resulted in the right to environment, also included, in Guyana, also included non-discrimination on the ground of sexual orientation, but the president refused to sign that into law in Guyana. And the bill, they excised it from the eventual law that was passed, the reform. So you have no rights about the environment, but not about sexual minorities. In St. Vincent, they attempted to reform the Constitution to exclude sexual orientation as a ground of non-discrimination, but that didn't succeed. But a similar kind of provision succeeded in Jamaica last year, and Jamaica actually amended their charter comprehensively, their Bill of Rights. And what Jamaica has done is to define marriage as a union between a man and a woman. So what they have done is to, in the Constitution, foreclose any kind of civil recognition of same-sex unions. So the situation in the Caribbean is quite, as I said, the trend is the opposite of everywhere else in the world. It's severe in terms of penalties and potential, and the trend has been to entrench that in the law, to reinforce the law by way of penalties and by way of its scope. The effect of this has been, well, this is the work of anthropologists and sociologists, but they have documented across the Caribbean, especially in places like Jamaica, the effects of these kinds of criminalization. And some of this work has been done in Guyana too. And it's been quite astounding, some of these things that have been traced in terms of public health effects. So there's a study by the UNAIDS that was published last year that actually showed how in Bahamas, after they decriminalized, HIV prevalence decreased. Whereas in countries where, like in the Caribbean, where criminalization still exists, and which it might be a factor in the law, its HIV prevalence rates are among the highest in the world. And one of the reasons for that, of course, is what anthropologists say, or sociologists, is the criminalization enforces stigma and discrimination. It drives people underground. They're afraid to access health services. They don't access prevention services. And so it creates a public health concern. The public health concern is not only around HIV, but also around STDs and suicide. Another UN study, but this was a UNICEF study a couple of years ago, it's available online, linked high rates of teenage suicide in certain parts of the US with, and teenage because I think this is when people are sexually maturing, with attitudes around sexuality. So and no doubt the same might be true for some places like Guyana, where there's a high rate of teenage suicide too, especially among East Indian communities. And there's of course, there are no studies, but there's a lot of speculation and talk about, how this might be linked or understood. There are other things. Criminalization in the law itself reinforces stigma and discrimination and allows, I think, it fosters a climate of violence. And we see that particularly in Jamaica with the dancehall music, the homophobic music, and the kind of violence that is very prevalent in the society. And then social effects from this, like in terms of education, I think perceptions around masculinity or femininity in education, which is one of the reasons that has been advanced for declining males in universities. And it was the subject of a big study in Cave Hill because of the way women are outnumbering men and outperforming men in tertiary education in Barbados. And here too, because as I was telling the class last week, I noticed at the graduation, women did consistently better at St. Augustine than men. Part of that is attitudes around masculinity, how men are perceived to be and how women are perceived to be. It's not to be studying and so on. It's not perceived as a masculine kind of thing. So all of this is attitudes again around not only sexual minorities, but also around gender and our construction or perception of gender. So the effects are quite, I think, broad-based. Not sure how much time I have, so I'll just briefly look at how international law, 5 minutes. I'll look at briefly at how international law has been moved. The trend in international law has been the opposite from the Caribbean, which has been, there are 3 stages we can discern. One is decriminalization. So many places did have these criminal laws. So in international law, the first step from the sexual minority communities was around decriminalizing, so removing these criminal laws. And then the second and third steps were around removing civil discriminatory practices. So in terms of family, inheritance, rights, non-discrimination. So a wide array of discrimination on the basis of sexual orientation. So you couldn't refuse a job if you were transsexual, if you were dressing in clothes that was perceived as the opposite sex. You couldn't be denied housing. You couldn't be denied an education. So things like that. And then you would be allowed to inherit property if you were in certain unions for a particular period of time. So the point is, it's not only about criminal exclusion, it's also about the ways that sexual minorities have been targeted by the law and don't share in the same kinds of civil benefits. And so the trend internationally has been first to decriminalize and then to extend to those civil benefits. And then finally, the third move has been full social inclusion or full citizenship, as it has been put in Canada. And that's been where unions have been recognized. So not civil unions, but marriage. And the terminology is quite, they say, significant or symbolic, because calling it a different name sort of reinforces the distinction between minorities and everybody else. So again, the important thing was about extending these rights to everyone. The last thing I'll say about the non-discrimination is that international law, it's often said, or it's often peddled, that international law, human rights law, doesn't take into account sexual minorities. And that's because when you actually look at the treaties, and they don't explicitly refer to, especially the wave of treaties that were enacted after or agreed to after the Second World War, which is when we see the international human rights movement really exploding. None of those conventions, the ICCPR and so on, actually mention sexual orientation explicitly. That said, international law hasn't remained static or remained at that place. They have interpreted the existing rights as to include non-discrimination on the basis of sexual orientation, and also as interpreting other rights as including or not excluding sexual minorities. So the approach has not been really to amend these documents, but to interpret them as living instruments or responding to this. And I'll just say the protocol to the European Convention explained why they didn't bother to amend these conventions, and they said that grounds like disability and sexual orientation, which were initially left out in the post-World War II period, what they said, they weren't rejected because of a lack of awareness or because they don't recognize that these grounds are now increasingly important. They say because such an inclusion, amending the documents, was unnecessary from a legal point of view, because the list of non-discrimination grounds is non-exhaustive. So they didn't find it necessary to amend these documents. So how have they found rights or interpreted these rights to include sexual minorities? One is by saying you can't discriminate on the basis of sexual orientation, and so they look at existing grounds like sex and say that includes sexual orientation, or where they have things like other and say that includes sexual orientation. And the reason for that, they identify sexual orientation as a personal characteristic. And they look at them, and what they identify is that those grounds relate to personal attributes, things that speak to human dignity, things that are immutable, that people can't change. And so they say, using that rationale, sexual orientation is included among those grounds because it's a personal characteristic. The other right that has been interpreted as including sexual orientation is privacy. And privacy not in a spatial sense, but privacy in talking about the liberty of the human person or the autonomy of the person to chart his or her own future. And so basically from these rights, international bodies have interpreted these covenants to include rights of sexual minorities. And finally, that move internationally has been echoed in a wide variety of jurisdictions, not Western alone. You'd be interested to know, so all across Europe, North America, Canada, and the USA, most countries in Latin America, Hong Kong, South Africa, Fiji, Australia. So all of these countries have followed this international move and have decriminalized and are moving towards full inclusion. Thank you very much.
Well, I know that you know the procedure by now, and thank you, Dr. Bulkan, but before we wrap, we do need to find out what questions you may have. So we'll entertain probably about 4 or 5 questions. Anyone? Yes, yes. Who's going to take the mic? Okay. Do state your name. And who's after her? So I can start a sequence this thing. Anyone?
Hello, good day. I'm Larissa. I found the presentation very thought-provoking. This issue seems to be very controversial. You mentioned something about natural law. And there's a great idea that they believe that human rights comes from natural law. How can you explain this if in the Caribbean they're arguing opposite? They're saying that this human right does not exist because it goes against natural law.
I didn't mention natural law, sorry.
You said that, what did you say? You said that they argue in the Caribbean that it is against natural law, like these same-sex unions is
Hold on,
against
the
natural law.
offense is called an unnatural crime.
Okay.
So it's not that they appeal to natural law. The appeal in the Caribbean is to more probably the rationale would be public morality, but not appeals to natural law. In fact, appeals to natural law are made by persons who, in international human rights law, because natural law is, but and that's not really the trend. The debate is really around public morality, issues of public morality, and whether that should inform criminalization of conduct that doesn't cause any harm. So we don't really see natural law figuring in this, I think, at the international level.
Thank you.
Any other questions concerning yes?
I have a question. Is there any legislation internationally which looks at rape among same-sex people? Because I noticed in Trinidad, our legislation which deals with rape only caters to the fact that a man can rape a woman, but in light of this new changing social circumstance, there will be instances where a person of the same sex can rape another person of the same sex.
I think rape is defined as the penetration of a woman. I think so.
Arlene, that's the common law definition of rape. It's been changed by statute in a lot of places, and I think Trinidad too. Yes? So you can, and in any event, whether or not, the reason why it's not, why the traditional position would have been it's only male-female, it goes back to the way the offenses have been described, which is that consent doesn't matter. Alright, so what the law prohibits is forcible conduct and consensual conduct. So they didn't need to have a separate offense of rape. They didn't actually need it because any kind of sexual activity between males was against the law. You follow that?
Yes. Thank you.
Anyone else? So, how many of us here would, because I mean, we even heard a little bit about constitutional reform here again. We find that there's a trend that even when people wanted to include sexual minorities or sexual orientation and non-discrimination based on that explicitly in a constitution, people refused to put it in there. In Guyana, the president refused to sign off on that, and in other jurisdictions. What do you think are the chances of something like that finding itself in our constitutional provisions here, if and when constitutional reform takes place? Anybody want to, make a guess on that? Do you think there will be a strong possibility that it will be in there or not in there? How many people say yes? Yes. She's over here.
I'm actually part of a group on campus here, a few students affiliated with the Institute of Gender and Development Studies called Support for Change. And we are actually advocating for the government to adopt a national gender policy, which includes reproductive rights, abortion, and all these controversial issues often fall under this. And we often get into debates concerning human rights and law, etc. Last night, I went to an event held by the Catholic Church regarding national gender policy and issues that they had from a religious perspective, in particular a Catholic perspective. And they really are calling for the policy to be abandoned and not adopted by the government because of this very issue, because they believe that it would legalize homosexuality. And these religious groups are really, really adamant. We have like Lawyers for Jesus, these Catholic groups. Even, yes, that's like our biggest challenge because they go in front of Parliament and, make real noise. We can't make no more noise on them. So, right? So I think the chances of something like this, I would really, really, really like to see, because our group has done a lot of work in terms of trying to get the public aware of the contents of the draft national gender policy, because there isn't one as yet, but there's the assumption that besides having all these wonderful pillars, poverty alleviation, domestic violence, all these things, agriculture and so on,
there's this idea that it will legalize homosexuality as well as abortion, and it will lead to a society being able to just do anything and everything, which kind of goes against this natural law that the bill mentioned there, and breaking down of barriers and chaos and so on. So as much as I would like to see it be implemented on a governmental level in terms of laws and so on, I don't think the chances are really that high. The chances are low. So to answer your question, I think chances are really low. And yeah, it's because we have so much religious obstruction. And you know, that's a question that I often come across as well. And like, I would like to pose to you all. How do we even, you know, find some sort of middle ground between allowing persons the right to practice their religion and allowing persons the right to just be and have freedom of sexual orientation and all these human rights? How do we find a middle ground between human rights and religious rights or cultural rights? Because these religious persons, from this group as well last night, they did say that they are all about human rights, all about human rights. Yes, of course. Why wouldn't you not think so? We are about human rights. We care about the baby inside the womb. How could you kill it? It's murder. So I was like, okay, so what about if someone gets raped and, you know, they're going through mental trauma and all that, they want to abort the child? So, you know, it's really, really difficult, and I would really like to know, how do I approach, like if I am in forums like this, because I try to be as professional and, you know, as possible, and I was, but how do I really find that common ground, and how do we form some sort of dialogue between religious groups and human rights groups who are calling for things like a national gender policy, human rights, equality for all, where sexual minorities and women have rights to their bodies, their sexuality.
Very good, very good. Oh, hold on. Oh, perhaps we should tackle that one before we go on to the next one. Write it down. So, yes, please. Comment. We need more than one mic next time. Yeah.
Yes, thanks. I just want to make a comment in response to the issues you've raised and Shledon asked. Indeed, they're very controversial issues about the rights to, you know, different persons with different sexual orientations, issues of abortion. These human rights issues, they can touch on persons' religious underpinnings and beliefs and your values, and therefore some persons would be very intolerant and very strict, believing that you have to maintain an absolute position of, you know, zero tolerance with regard to anything that appears to infringe upon that right. And I just talk about my own belief and my own evolution and change, because I had a very intolerant view, but I think through education and awareness I've come to have a different view, and I believe other persons might also adopt a different view through education and understanding all of the different parameters. So I'm not giving like a legal answer, I'm just telling you from a personal perspective that I remember years ago, you know, one time I looked at Oprah. I love to look at the Oprah show, and she had someone there who was a transsexual, and I was like, oh, why should you have someone like that in her show? I didn't want to see it. I had zero tolerance. But then when you listen to the other side and you get education awareness and you understand the different views that, you know, biologically if someone is that way, then what do you expect? And if it's not harming you, why can't you be more tolerant? So really, education is about awareness and being a bit more tolerant to different views, because we're in a universe, in a society with different cultural values, different beliefs. And look at even President Obama, when he said his views has evolved, that yes, he had his religious underpinning and a different view, but now from a state perspective, from a head of government perspective, he's become more tolerant to realize that all persons should have rights, and if someone chooses to live away and it is with dignity and integrity and it doesn't harm the other person, then why can't you be more tolerant? So I think it comes down to education awareness, that I can understand from my own personal perspective why you grew up one way and you form opinions about, you know, others in society based on the limited education and awareness, because you don't even want to hear it. You're like, oh, it's going to contaminate me if I should even allow you to speak. But once you agree to be more tolerant and to allow the other side to speak and to hear their views, then you really wait, well, this doesn't harm me. I can choose to have my own religious views and my own beliefs, and the same way we have, you know, we're a pure society with different religions, different beliefs, and we can all come together and respect each other. Then we need to have the respect, and the state and the laws then would have to develop along that line to give recognition to, the state has to be separate from religion, right? And give recognition to civil rights and liberties as a separate issue from a religious view.
I'd just like to touch on 2 points. The first point is the abortion point, and most people tend to make that question, what happens if the woman was raped? And I mean, while it is a valid point, I have my own views on abortion. I just think people need to recognize that we don't live in a theocratic state. We're not governed by a Bible. And if the Catholic Church or any other church has a view on abortion, then let them police it within their church. Exactly. My question would be to the Catholic Church, what happens if someone wants to have an abortion but does not subscribe to your particular religious persuasion? That's my issue.
I asked those questions last night as well, and they mentioned things like having faith and not being straight away, and she also said that the Hindu and Muslim societies also feel the very same way about things like that.
The view of human rights really should not be...
She was very educated and informed. So, like she said, going back to education, she is very educated in the topic. She understands gender very well. But again, this whole idea of, I don't know, sainting of society, and going back to, she even mentioned that Aspire said abortion was murder. And they don't see the baby in the womb.
But there shouldn't be a selective application of human rights. There shouldn't be it. It should be, the human right is the right to liberty, to privacy, and it should apply across the board. How you see, the court will determine what that is. But the church, I don't think, should get involved in determining that they have a view on homosexuality. Therefore, it should not be guaranteed to persons. If the Catholics in society don't want to engage in a practice, that's their issue. But it should not be a basis for not allowing abortion or any other policy that could be against a particular belief.
You said 2. That was one.
Yeah, I just want to same points that both of my colleagues mentioned, which is around, they both said it, that in the Caribbean we live in constitutional democracy. So now that's a very important point. We're not governed by a particular religious text, and I think that's the fundamental point that you have to be aware of. And I just wanted to add to what they have said by comparing what India's done, which India could be. You might think India is like Trinidad and Tobago because a lot of Trinidadians are Indo descendants, right? Same prohibitions in the Indian law that they inherited from Britain when Britain colonized them. And when they dismantled it, I think it was 2 years ago, what the court talked about, the High Court of Delhi, was that they formulated this concept, and it comes back to your question a bit about natural law, which natural law again isn't used, but this whole thing about natural and unnatural. What they talked about was a constitutional morality. That's what has to govern. So the Constitution has a morality that has nothing to do with the Bible or the Gita in India or whatever. So it's what values are you have you agreed to be ruled by? And among those values are things like respect for each other, human dignity, and so on. And that's why it's a human right. The other thing that you mentioned, you talked about you would legalize homosexuality. You said that about two times, right? Legalize homosexuality. The thing is, homosexuality is not illegal.
Yeah, this is the term that they use.
Yeah, but you must correct them when they use it. Yeah, because you can't legalize an orientation. Legalize or make illegal an orientation. But we're saying like criminalizing Indianness, yes, or criminalizing being left-handed. So it's what is criminalized is certain types of behavior or acts, but not an orientation. Yeah? And that was the point Trinidad and Tobago Court of Appeal made in Surat. Yeah, what I'm saying, the legislation criminalizes certain acts or behavior, but not an orientation.
Which is sodomy, right?
Yeah.
Which is, penetration.
Yeah.
But then...
And also serious indecency.
Right, and they only see that as being part of the homosexual sector or domain.
Well, sodomy is practiced by heterosexuals too.
Also
yes.
have that type of sex as well. So.
Yeah.
No, I think interestingly, when these debates come up, we live in a secular state or we're living in a religious state. We're living in a secular state. We're bound and by what's in our constitution. And it's not a Bible or a Gita or Quran that is our supreme law. However, religiosity, if you want to call it that, pervades almost every aspect of our society. And Mr. Affonso spoke about cultural relativism earlier. So if our culture says, well, these things are wrong, is it an excuse to deprive people of their fundamental human rights, whatever that is? So perhaps that would be something that we'll address in our next round of discussion.
Well, as you raise it, it's also selective sort of, it's a misinterpretation of what these documents say. Because religious scholars are not united in the Bible, and these other documents actually prohibit, in fact the word homosexuality doesn't appear in the Bible. So they're not united, they're different. These are all texts that are hundreds of years old, or thousands maybe, I don't know. And there's no unanimity in what they mean. So it would be chaotic to actually legislate on the basis of them. The other thing is, legislators sort of conveniently legislate on the basis when they talk about religion, but most of our laws have nothing to do with religion. And most of these practices in the Bible that the Bible talks about in a bad way, maybe, I don't know, things like adultery and so on are not crimes. On the other hand, things that the Bible practices, like polygamy, levirate marriage, and so on, stoning your son if he's disobedient, those things are viewed with revulsion by modern societies. So the point is, legislating on the basis of the Bible is quite problematic. And we don't. Most societies don't.
You had a question?
But in the last couple of months, right, concerning international law, we've been hearing this word about interpretation of the law, and just asked whether or not it will be enacted in our constitution. To the extent when it isn't enacted, and we come to the interpretation of the law where this issue of decriminalizing sexual minorities, is it safe to say that we will be adopting, it will be a faster process to adopt the idea or to conform around the idea of sexual minorities when it's accepted by persons who our decisions are bound by?
You mean by the decision makers?
Yeah, like from the English or the Privy Council or these things.
So, you said interpretation.
You just asked if, how long will it take to be incorporated in our constitution? And the time they said it will take a while. So my question is that the process for it to be incorporated in our constitution, would it be determined based on the fact that, or based on the time in which other countries incorporated?
I think that's a political matter. That would depend, because laws are made by Parliament, and so I think that depends on how politicians perceive what's the mood and so on.
So they look at global trends.
But I don't think global trends alone will influence it, because they're more concerned about votes. And global, you can't get global votes. Yeah.
I have had some recent drafts of the Constitution when the last administration was trying to amend the Constitution to have persons vote for a president as opposed to a prime minister, as opposed to an executive president. And it never got any further because no one could agree on what the Constitution should have in it. So we had the draft, we had, I can't remember the name of the other draft, but the thing is, it's not the court doesn't tell us what we can do. It's not an issue of time in relation to when after the period after judgment is made or when, how many countries in a particular jurisdiction, region. It really depends on us and what our government thinks people want.
We live in a democracy, and I suppose at the end of the day, it depends on us. At the end of the day, it depends on what we as a people think. So thank you for that question. And it is about 4 after 12. So, at this juncture, we're supposed to have another speaker, but it's a community show. At this juncture, we would like to give some tokens of appreciation, or do give Mr. Bulkan a round of applause, please. Let's not be stingy with those applauses. And we do have to do some of the formalities of saying thank you and giving some tokens of appreciation. So, Ms. Arlene Chochan, I don't know who's going to go first. Very good. So, first, let's have Mr. Timothy Affonso presented with this token of appreciation from the Law Society for his stellar contribution today. There was a photo up there. Was that photo taken? It was taken there? No. Do that again. Do that again. Because there are magazines that are published by these people. Yes, definitely. Very good. Very good. Round of applause. Now, do make some space for Miss Alicia Elias-Roberts. Yes, very good for her contribution. Very good. And finally, Dr. Bulkan. Yes, and do capture this one as well. Beautiful. And now we have to do the vote of thanks, and that will be done by none other than Ms. Chochan. Take it away.
On behalf of the Chairperson of Law Society, I would like to thank all our presenters for taking time out in this schedule to come and impart their knowledge to us on different human rights issues. I also like to thank the attending people for taking time out. I know some of you have classes, and some people took time out from their classes to come to our seminar, so I'd just like to say thank you very much.
Yes. And I wish I had the privilege of saying that there is refreshment at the back, but there is none. But thank you very much for your time and attention, and we will do this again